Everyone, and welcome to the third in our disciplinary series of Monday Mode Sessions, a series of videos where we demonstrate some typical HR meetings with the help of our friends in business. And you may remember last week, Lisa held a disciplinary meeting with Jan and decided to give him a written warning about his poor timekeeping. At the end of this meeting, he was given the chance to appeal, and he's now done so. As investigator, I can't hear his appeal, and as disciplinary officer, Lisa can't hear his appeal either. So we've passed Jan's appeal to Sally to act as an independent appeal person, and I'll be narrating throughout. So let's go over to Sally and Jan to see what should happen in an appeal hearing.
Hi Jan, to confirm, this is an appeal hearing, the purpose of which is for you to outline your reasons why you are appealing the decision made by Lisa last week to give you a written warning for your poor timekeeping. Claire is here to take the minutes and a copy will be provided to you after the meeting. I am here to listen to what you have to say, but I won't make a decision today. I may need to investigate further, so you will get a written response. As per the invite letter, you have been given the opportunity to have a representative at the meeting. You have declined this. Can you confirm that you are happy to proceed?
Yes.
Okay, so please can you explain the reasons for your appeal?
An appeal could be based on one of two things. A review of the evidence, so for example when new evidence comes to light that may not have been available at the disciplinary hearing, or a reconsideration of the decision because the employee feels the decision itself was unfair. In this instance, Jan is appealing because he feels the decision was unfair.
Well, firstly, I want to appeal because I wasn't allowed to bring my brother with me to the disciplinary. He's a solicitor and I wanted him to be there to help me. But I was told I couldn't. I'd have liked him here today too, but you said no again.
Okay, I do understand your frustration with that, Jan. However, you only have the right to be accompanied by a work colleague or a certified trade union representative. Experience really tells us that involving family members is not a good idea. They can often feel emotional and defensive on behalf of the employee, and it leads to a very unproductive hearing.
As we mentioned last week, employees do ask sometimes to bring family members or legal representatives, and you are within your rights to refuse this. It's generally not a good idea to allow family members for the reasons Sally has just outlined. In terms of legal representation, this isn't a statutory right, and it's generally not a necessity in disciplinary hearings. However, if the employee's ability to practice their chosen career was at stake, so for example, a doctor was about to be dismissed for something that could see their license to practice medicine be revoked, then case law suggests they should be allowed to have legal representation present at all stages of that formal process. Here, Sally's explained this to Jan, and it really isn't part of his appeal. It has no bearing on the outcome of his disciplinary. So let's assume Sally has now dealt with this point.
So is there anything else, Jan?
So I think the decision to give me a warning was too harsh. I was only late a few times, and on one occasion I was late because of childcare.
You may remember from the original investigation this was dealt with at the time. Jan had rung his manager and followed procedure in this instance, and when Sally does her investigation, she will find this in the investigation notes and will discount this point of appeal as it didn't actually form part of the disciplinary decision.
Also, my cat's been poorly and it's been keeping me awake at night. I've been worried about her. We've been back and forward to the vets.
Okay, did you mention this at the disciplinary hearing?
No.
So if it was a reason for your lateness, why didn't you mention it?
I really just didn't think about it.
So here, Jan has presented some new information that he didn't raise at the disciplinary hearing. The natural first question is why not? It could be that the employee felt it was something personal or not relevant, or it could just be that once they've gone home and thought about the disciplinary, they've thought of much better reasons that they should have given. It's up to Sally now to investigate this and decide if it does provide mitigation or not. In this instance, Jan may have another reason for his poor timekeeping, but it doesn't excuse the fact that he didn't call his line manager to report his lateness, so it's probably not going to have a huge bearing on that written warning.
Is there anything else you want to add?
Not really, just that I apologise for being late and for not ringing. I feel like a written warning is really too much, as I've been trying really hard to make an effort to improve on things.
Okay, so to sum up, you're appealing because you feel that you were only late a few times. You were late once due to childcare. You haven't been sleeping because your cat's been ill, and you apologised at the disciplinary and have been trying harder to be on time.
Oh, we lost Jan. Jan, have we lost you? Okay, so what will happen next is that Sally will adjourn the meeting and confirm to Jan in writing the outcome of his appeal. So she's going to consider her response and confirm that in writing later on. In this instance, it doesn't look like Jan's appeal will be successful. He's included things that just weren't part of the disciplinary and has given a little bit more mitigation for his actions, but not really anything that changes the fact he was late and didn't follow procedure. So it's likely Sally will inform Jan that his appeal is not upheld. Also, if you remember from the initial investigation, Jan had been spoken to about periods of lateness informally, but he still failed to get to work on time. So the formal disciplinary action was the next logical step. Sally will be able to reference this in her appeal outcome letter, together with confirming that the childcare instance was not part of the process and was dropped at investigation stage. Jan will get Sally's decision in writing in a few days' time. So what's next if he's still not happy? Nothing. Appeal is the final stage of the internal process. The next port of call if an employee still isn't happy with this is a tribunal. In this instance, because Jan has been given a written warning, the only course of action open to him would be to resign and attempt to claim constructive dismissal. But it'd be very hard to prove that the written warning made his employment with the company untenable. Hopefully, the sanction will have done what disciplinary sanctions are there to do and improve behaviour and lead to no further formal action. Thanks for joining us over the past 3 weeks as we took you through the disciplinary process, investigation, disciplinary hearing and appeal. We hope you found our videos useful, but if you have any questions, please feel free to get in touch.